The Zambia Law Development Commission wishes to inform members of the public that a simplified version of the Electoral Process Act number 12 of 2026 has been prepared in Zambian Sign Language to facilitate wider public understanding of the law and its provisions relating to the electoral process. Members of the public are advised that simplified version is intended solely as an explanatory aid and should be read together with the official text of the Electoral Process Act number 12 of 2026. Copies of the simplified version may be accessed electronically through the official website of the Zambia Law Development Commission. The Commission encourages all citizens, stakeholders, civil society organizations, professional bodies, and other interested persons to familiarize themselves with the context of the Act and engage with the simplified materials made available. The Commission remains committed to promoting public awareness, accessibility, and understanding of Zambia's laws through the provision of legal information in formats and languages that are accessible to all members of society. Short title. This provision will be called the Electoral Process Amendment Act 2026. It should be read together with the existing Electoral Process Act. Amendment of Section 2. A campaign period means the time that starts after nominations close and end on the day before the election, as decided by the Commission under Section 28. A candidate means a person contesting an election for President, Member of Parliament, or Councilor and seeking votes from the people, as well as a person included on a political party's list for seats allocated under the proportional representation system in Parliament or local councils. The Code means the Electoral Code of Conduct in the first schedule. A presiding officer means a person appointed by the Commission under Section 37B to supervise voting at polling stations. An adoption certificate means a certificate signed by the President and Secretary General of a political party, or in the absence of the Secretary General, the President and the Deputy Secretary General of a political party, in the prescribed form, confirming that the political party is sponsoring or supporting a candidate for election as President, Member of Parliament, Mayor, Council Chairperson, or Councillor. A Deputy Secretary General means a person appointed as the Deputy Secretary General or someone holding a similar position in a political party according to the Societies Act. A nomination petition means a petition filed in accordance with Section 95A. A party list means a list prepared by a political party for use in the proportional representation electoral system and submitted to the returning officer or district electoral officer in accordance with Section 36C. A person with disability has the meaning provided in the Constitution. A president means a person recognized as president of a political party under the Societies Act. A Secretary General means a person recognized as Secretary General or holding a similar position in a political party under the Societies Act. A youth has the meaning assigned to the term in the Constitution. Section 12. The provision has been changed by adding the word new right after the words registration of. Amendment of Section 13. Section 13 has been changed by adding new subsections. The new provision provides that the Electoral Commission can decide the period during which the provisional register of voters will be open for inspection. Further, registered voters are allowed to check the provisional register online during the period set by the Commission. Amendment of Section 17, subsection 1. The law now provides that if a person whose name is in the provisional register of voters notices a mistake on their personal details, they must inform the Electoral Commission within 14 days instead of 90 days. Amendment of Section 27. The law changes the section reference from Section 20 to Section 24. Amendment of Section 28. Election timetables and any changes to them must be published not only in the Government Gazette, but also in newspapers or electronic media chosen by the Electoral Commission. Amendment of Section 30. The provision has been changed to introduce new requirement for candidates sponsored by a political party. These candidates must now submit an adoption certificate for their political party as part of their nomination documents. As a result of this addition, the paragraphs in the provision have been rearranged and renumbered. The change also requires the Electoral Commission to publish the details of all validly nominated candidates in the Government Gazette, in a newspaper with nationwide circulation, or through electronic media chosen by the Commission. In addition, because of a new provision which has been inserted, the numbering of the existing provisions has changed, with the former provisions, subsection 2 and subsection 3, now becoming subsection 3 and subsection 4. Amendment of Section 31. The provision has been changed by adding a new provision providing that a nomination paper and affidavit must be submitted together with an adoption certificate for candidates sponsored by political parties. Although independent candidates are not required to provide an adoption certificate, the change also requires the Electoral Commission to publish the details of all validly nominated candidates at nomination centers. Replacement of Section 33. The provision replaces Section 33 and provides that a person standing as a councillor, mayor, or council chairperson must submit a nomination paper and affidavit to the returning officer in the required form. If the person is sponsored by a political party, the nomination must also include an adoption certificate from that party, but independent candidates do not need this certificate. For district elections, the nomination paper must be sponsored by at least 15 registered voters from that district in the presence of the returning officer. For ward elections, the nomination paper must be supported by at least 9 registered voters from that ward. The supporters must show both a voter's card and a national registration card as proof of identity. The law also provides that a person standing as a mayor or council chairperson must have a council tax clearance certificate where applicable. In addition, the Electoral Commission must publish the details of all successfully nominated candidates at nomination centers. Insertion of Part 4A. A new Part 4A has been added which introduces the proportional representation system. Under the proportional representation electoral system, the seats reserved for women, youths, and persons with disabilities will be distributed by the Electoral Commission after the election among the political parties. Each political party will get a number of these seats based on how many votes it received during the election. Section 36A. Eligibility for participation in proportional representation electoral system. The law now provides that a political party that wants to contest seats under the proportional representation system must also have a candidate standing for election as president. Section 36B. Formula and distribution of seats under proportional representation electoral system. This provision provides that the Electoral Commission must use the formula provided in the second schedule of the law to share proportional representation seats in the National Assembly and councils among political parties, according to the total number of valid votes received by each party's presidential candidate in the first round of voting. The Commission must complete this process within 7 days after the President-elect is sworn into office. If a political party refuses to accept a seat that has been allocated to it, the Electoral Commission must give that seat to another political party that qualified for a seat using the same formula. In the event that a political party refuses the seat, the votes received by the presidential candidate of that party will no longer be counted when resharing the remaining seats. Section 36C, submission of party list. The provision is new and provides that a political party must submit its party list to the Electoral Commission within 7 days after seats are distributed. The list must be in the required form and the party must pay the required fee. The party list must be signed by the party president or secretary general. This shows that the list is official and approved by the party leadership. For parliamentary seats, the party list must be given to the returning officer. For council seats, it must be given to the district electoral officer. A political party cannot include on its party list a person who has already taken part in an election under the first-past-the-post system. This means the same person cannot take part in both electoral systems at the same time. Each candidate on the party list must also sign a consent form. This means the candidate must agree to be on the list. If a candidate on the list dies, resigns from the party, or is expelled before the names are published, the Commission can ask the party to submit another list within a time it sets. The Commission will publish the party list only if the candidates meet the legal requirements for Parliament or Council positions. If a candidate does not meet those requirements, the Commission will tell the party to correct the list within a set time. And if it fails to submit a party list on time, the vacant seat will be given to another party that qualified under the seat distribution formula. Further, if a party fails to submit a party list, the votes its presidential candidate got will not be counted when distributing seats. Section 36D, requirements of party list for seat in National Assembly. The new law says that when a political party gets special seats in Parliament through the proportional representation system, it must submit a party list for each category, for women, youths, and persons with disabilities. The youth list must include candidates who are youths for the whole term of Parliament. The disability list must include candidates from different disability groups, and the candidates on the list must have registration certificates under the Persons with Disabilities Act. These lists are then submitted to the Electoral Commission, which uses them to decide who will fill those special seats in Parliament. Section 36E, number of councillors under proportional representation electoral system. The law explains how special councillor seats in a council are shared among different groups. The number of proportional representation councillors is first calculated using a formula based on 18% of the constituency-based seats in the National Assembly. Once the total number of these seats is determined, they are then divided among three groups, namely women, youth, and persons with disabilities, in the ratio of 4 women, 3 youth, and 1 person with a disability. while ensuring that each group gets at least one seat, even if the numbers are small. In situations where the total proportional representation seats in a council are less than 3, the law still requires that there must be at least 3 seats, with 1 seat allocated to each group. The Electoral Commission is responsible for announcing and publishing the number of proportional representation seats allocated to each council in accordance with the law. Section 36F. Requirements of party list for seat in council. This provision means that when a political party is putting forward names for seats in a council, it must not submit just one general list. Instead, it must prepare separate party lists for each special category of seats it has won, namely women's seats, youth seats, and seats for persons with disabilities. The words subject to Section 36E mean that this rule must be read together with Section 36E. And if that section gives a special rule or limitation, that other rule will also apply. In simple terms, the party must match its list to the number of reserved seats it has obtained in each category. For the youth category, the law requires more than just putting a young person on the list at the time of nomination. It says that the candidates on the youth party list must remain youth for the whole period of the council's term. This means that the person chosen must continue to fall within the legal definition of a youth until the end of the council term. The purpose is to make sure that the seat continues to be held by someone who truly belongs to the youth category, not someone who only qualified at the beginning but no longer does later on. For persons with disabilities, the law is also strict. The party list must include alternates from different types of disabilities, which means the list should not be made up of only one kind of disability. It should reflect the variety of disabilities so that representation is broader and fairer. In addition, the candidates must have a certificate of registration issued under the Persons with Disabilities Act. In simple terms, this means a person cannot just claim to have a disability and be placed on the list. There must be official proof that the person is properly registered under the law. The overall aim of this provision is to promote fair representation, proper verification, and genuine inclusion of women, youth, and persons with disabilities in council membership. Section 36G. Publication of party list. The Commission must act within 7 days after receiving a party list under Section 36C. It is required to process the list and then publish the names of the members of Parliament and councillors who have been allocated seats through the proportional representation system. The names must be made public in the Government Gazette, in a newspaper that is widely read across the country, or through any electronic media that the Commission chooses. Section 36H. Vacancy in office of Member of Parliament under Proportional Representation Electoral System. This provision is about what happens when a seat in Parliament held under the proportional representation system becomes vacant, and how that seat is replaced. In simple terms, it provides that proportional representation members of parliament are still subject to the Constitution when it comes to losing a seat. But there are also special rules for party lists, party discipline, replacement, and late vacancies. First, subsection 1 means that the usual constitutional reasons for an MP's seat becoming vacant also apply to an MP elected under proportional representation. Those reasons include resignation, disqualification, misconduct, leaving or being expelled from the sponsoring party, losing citizenship, disqualification by the Constitutional Court, and death. The effect is that a proportional representation member of parliament is not treated as permanently secure just because they entered parliament through a party list. Second, subsection 2 adds an extra rule that is specific to proportional representation. The political party that sponsored the MP may recall the MP at any time during the life of Parliament. In plain language, the party can remove its own proportional representation members of Parliament from Parliament even if none of the normal constitutional grounds has occurred. This gives the party much tighter control over PR seats than it has over ordinary constituency seats. Third, subsection 3 says that if a person causes a vacancy for the listed reasons, that person is punished during that parliament by being barred from contesting an election or being placed on a proportional representation list, and also barred from holding public office. So the law is trying to discourage people from resigning, defecting, acting contrary to the rules, or otherwise triggering a vacancy and then returning immediately to politics. Fourth, subsection 4 requires the Speaker to notify the Electoral Commission in writing within 7 days after a PR seat becomes vacant. This is simply the reporting step that starts the replacement process. Fifth, subsection 5 says the Commission must fill the vacancy within 90 days by using the next available candidate on the same political party's list. In simple terms, the person next in line on the party list moves up to take the seat. This is the core replacement rule for PR seats. Sixth, subsection 6 deals with the situation where the party list has run out of eligible names. If there is nobody left on the list, the Commission must ask the party to submit an additional list within 30 days. Subsection 7 says the same rules on qualifications and list requirements apply to that extra list as well. Seventh, subsection 8 says that if that party does not submit the extra list on time, the seat does not remain empty forever. Instead, the Commission reallocates the vacancy to another political party that qualified under the seat distribution formula. Subsection 9 adds up the votes of the non-compliant party's presidential candidate will not be counted in that redistribution. The likely purpose is to stop a party from benefiting from the system while refusing to follow the list of rules. 8th, subsection 10 says that if the political party is dissolved, the proportional representation member of parliament automatically stops being a member of parliament, and the seat is reallocated to another party that qualifies under the formula. This means the seat belongs to the party structure, not to the individual MP personally. Finally, subsection 11 says that if a vacancy happens within 180 days before a general election, it will not be filled. The practical effect is to avoid appointing a replacement for a very short remaining period before Parliament ends. I. Vacancy for councillors in proportional representation electoral system. The provision explains what happens when a councillor who was elected through the proportional representation system leaves office or loses the seat. A councillor elected through a political party list can lose the seat for reasons already provided for in the Constitution, such as resignation, disqualification, or other legal grounds. In addition, the political party that sponsored the councillor has the power to recall or remove the councillor at any time during the council's term. When a councillor's seat becomes vacant, the town clerk or council secretary must inform the Electoral Commission in writing within 7 days. After receiving the information, the Electoral Commission must fill the vacant seat within 90 days by selecting the next available person from the same political party's list. This ensures that the political party keeps the seat it originally won. If the political party has no more names left on its list, the Electoral Commission will ask the party to submit another list within 30 days. The new list must follow the same rules that applied to the original party list. However, if the political party fails to submit another list within the required period, the vacant seat will be given to another political party that qualifies under the formula used for sharing proportional representation seats. In that situation, the votes received by the presidential candidate of the political party that failed to submit the list will not be considered when redistributing seats. The provision also states that if a political party is dissolved, any councillor holding a proportional representation seat under that party automatically loses the seat, and the seat is redistributed to another qualifying political party. If the vacancy happens within 180 days before a general election, the seat will not be filled because the country will already be preparing for new elections. Part 6. Returning officers and presiding officers. Repeal and replacement of Section 37. Previously, the law provided that after announcing an election date, the Electoral Commission would appoint a presiding officer for each polling station. The amendment removes that system and instead requires the Electoral Commission to appoint a returning officer for every constituency, district, or ward through a notice published in the Government Gazette. Their duties include supervising electoral activities, managing nominations, overseeing polling officials, collecting and collating results, and handling election administration in that area. In simple terms, the law is changing from focusing mainly on polling station management to focusing on wider election management at constituency, district, and ward level. The new law also allows the Electoral Commission to appoint these officers without waiting for an election date to be announced. which can improve preparation and coordination for elections. Another important change is that the appointment must now be published in the Gazette. This makes the process more official and transparent because the public and political parties can know who has been appointed to manage elections in each area. Insertion of sections 37A and 37B. Powers and duties of returning officer. A returning officer is the official responsible for managing elections in a constituency, district, or ward. Their role includes supervising and managing all election activities in their area, handling the nomination of candidates who are officially approved to contest elections, and collecting as well as compiling election results from polling stations. They are also responsible for announcing the winners of National Assembly and local government elections in their area, and announcing presidential results at the constituency level. In addition, they perform any other election duties assigned by the Electoral Commission. In summary, the returning officer ensures that elections in their area are properly conducted and that the results are correctly processed and announced. Appointment of presiding officer. After the Electoral Commission sets the date for an election, it must appoint a presiding officer for every polling station where voting will take place. The presiding officer is the person responsible for supervising and managing voting activities at that polling station on election day. Part 7. Voting, Counting, and Results. Amendment of Section 60. Both the previous provision and the amendment explain what a voter must do after receiving a ballot paper at a polling station. The process in both laws is almost the same, but the new law makes small wording and structural changes to modernize and simplify the voting procedure. Under the previous provision, after receiving a ballot paper marked by an election officer, a voter was required to enter an empty voting compartment, secretly mark the ballot paper for the candidate they wish to vote for. Fold the ballot paper to hide the vote, place it in the ballot box, and immediately leave the voting station. The amendment keeps the same voting process, but changes some words and sentence structure. Instead of saying voting compartment, it now uses the words voting booth. Both terms mean the private place where a person votes secretly. The amendment also removes the phrase marked under subsection 5, paragraph C, and instead simply refers to a ballot paper referred to under subsection 5. This broadens and simplifies the wording so that it applies generally to the ballot paper issued to the voter. Another change is the word about choosing a candidate. The previous provision stated that the voter should mark the ballot paper to show the candidate the voter wishes to vote for, while the amendment states that the voter should indicate the candidate the voter intends to vote for. Although the meaning is practically the same, the new wording is more direct and modern. The final change is mainly technical. Previously, the last paragraph was labeled F, even though there was no paragraph E, which was likely a drafting mistake. The amendment corrects this by properly labeling the last paragraph as E. Amendment of Section 68. The provision changes Section 68 by updating the side note of the section and explaining how rejected ballot papers should be handled during vote counting. The provision also states that when a ballot paper is rejected during counting, the presiding officer must write the word rejected on the back of that ballot paper and keep it separate from the valid ballot papers. This helps to clearly identify rejected votes and ensures that the counting process is organized, transparent, and easy to verify. The amendment changes the title, side note, of the section from counting of votes and announcement of provisional results to counting of votes and announcement of results. Removing the word provisional, which makes it clearer that the section deals with both counting votes and declaring election results. This change also replaces the rejection marking requirement so that instead of marking A for rejection, the presiding officer must simply mark rejected on the back of each rejected ballot paper and file it separately. Previously, Section 68 required the presiding officer, after polling, to open ballot boxes, sort ballot papers according to each election held at the polling station, compare the ballot papers with those issued, count the votes for each election, and announce and publish the results in figures and words at the polling station. It also provided that ballot papers would be rejected if the ballot paper indicated the name of the voter, votes cast for more than one candidate, were unmarked in a way that made the voter's choice unclear, did not bear the official mark, or were not official ballot papers. Amendment of Section 70. The new provision has changed by the removal and replacement of the side note of Section 70 from objections concerning counting of votes and announcement of provisional results to objections concerning the counting of votes and announcement of results. Amendment of Section 71. The provision has changed by deleting the old side note, which stated that procedure concerning provisional results and voting materials, and is replaced by procedure concerning results and voting materials. Amendment of Section 72. This provision changes by the deletion of Section 72, subsection 1, and provides for the duties of a returning officer after receiving election materials under Section 71. In simple terms, once the returning officer gets the election results from a polling station, must count and compare the results from the polling station for the constituency, district, or ward, and then deal with the results in a way the law requires. The main purpose is to make the process of handling election results clearer and to bring the wording of the law in line with the elections as provided by law. Compared to the previous section 72, subsection 1, the amended provision is broader and more detailed. The provision only addressed the announcement of presidential and mayoral or council chairperson election results and referred to the declaration of results for National Assembly and ward elections. The amendment now includes presidential, member of parliament, mayoral, council chairperson, and councillor elections in the announcement stage. It also specifically says that results for a member of parliament, mayoral, council chairperson, or councillor election must be declared. Part 8. Voter education and nomination petitions. Repeal and replacement of Section 80. The amendment broadens the responsibility of the Electoral Commission by requiring it to provide voter education generally, rather than only during an election period. Previously, the law limited voter education to a specific election. The amendment now allows the Commission to educate the public continuously on matters such as voting procedures, voter rights, registration, and democratic participation. This amendment changes voter education from a temporary election activity into an ongoing duty of the Commission. Insertion of Part 8A, Nomination Petitions. A new Part 8A has been added which introduces the nomination petition, which is a formal complaint made to a court or other legal authority challenging the nomination of a candidate in an election. If a person wants to challenge the nomination of a candidate in court or before a tribunal, they must submit a nomination petition using the official form and procedure required by the law. Rules relating to nomination petition. The provision gives the Chief Justice power to make rules on how nomination petitions are filed and handled in court, including procedures, timelines, fees, and costs. It also gives a person who files a nomination petition the right to appear in court and be represented by a lawyer or other representatives. Amendment of Section 110. Section 110 has been updated to make things clearer and to change what the Commission can do. It now clearly states that the Code of Conduct is in the first schedule of the Act. It also changes the penalty for breaking the code from disqualification to suspension, meaning a party or candidate can be temporarily stopped instead of being permanently removed while still ensuring they follow the rules. Amendment of Section 125. The new provision simplifies Section 125, subsection 2, paragraph W, by narrowing the Commission's power on delimitation. Under the previous provision, the Commission could make regulations for the delimitation of provinces, constituencies, wards, and polling districts. The wording in the amendment removes provinces from that list. So the Commission's power now applies only to the delimitation of constituencies, wards, and polling districts. General Amendment. This provision changes certain words used throughout the law. Wherever the law previously used the words compartment or compartments, those words are now replaced with booth or booths. Amendment of the schedule. The amendment only changes the heading by inserting the word first before the word schedule. This change does not alter the actual content of the schedule, but simply clarifies that the provision specifically refers to the first schedule. Insertion of second schedule. The second schedule explains how reserved seats for women, youth, and persons with disabilities are shared among political parties under the proportional representation system. The Electoral Commission does not give those seats randomly. Instead, it uses a clear mathematical formula based on the number of valid presidential votes won by each political party. The process starts by adding up all the valid presidential votes cast for parties that are qualified under the law. Rejected votes are left out because they do not count. After that, the total valid votes are divided by the number of reserved seats in each category to find the target, which is the number of votes needed for one seat. For example, women have 20 seats, youths have 15, and persons with disabilities have 5. So each category has its own target. Once the target is known, each party's votes are divided by that ratio to see how many seats it has earned. If a party gets a whole number and still has a leftover fraction, that leftover is not wasted. The remaining seats are then given to the parties with the biggest surplus fractions. If two parties have the same surplus and only one seat is left, the law says the seat should be decided by lot, meaning by a random draw as prescribed by the rules. The schedule also makes it clear that a party must first meet the target for a category before it can be considered for seats in that category. If it does not reach the target, it drops out of that round. For council seats, the same formula is used, although the number of seats in each council may differ. The tables in the schedule simply show the formula in action. They help ordinary readers see how the votes are turned into seats for women, youths, and persons with disabilities. In short, this schedule is the seat sharing formula that turns election support into reserved representation in a fair and organized way. Thank you for watching.